hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we're going to do part 2 of the things that you should not put in your will because they create problems. And so we had mentioned several of them in our part 1. And Matt, what else have we not covered thus far?
So, keeping in line with the organ donation and all that stuff, a lot of things people also ask us, should we put life support or do not resuscitate, a DNR, into our will? My answer is no. You don't need to do that. Why? Because you should have a good power of attorney for healthcare that already addresses that. That section that people are looking for is typically called the living will. What's really annoying about it being called a living will is that it's not part of the will. It's a completely different thing. And so most of the time, what I like to do is we'll put the living will as a part of the healthcare power of attorney. It's all under one thing. And so there's no reason to double up because, kind of like what we mentioned in the last video, what if you change your mind? What if that action is not feasible? What if? And so you want to make it as concrete and as succinct and as simple as possible. It's not going to be simple if two different wishes are in two different documents.
Yes, that's a very good point. And I think it is also interesting to talk about the fact that, again, you may change your mind. You may decide that at one point in time you feel so horrible, and or rather you think I'm definitely in a position where I want to reject life support no matter what. And then you change your mind. Now it's there in the will, and you're deciding that you may or may not want to have this life support. And so it's just far better to have that designation of that authority inside of the power of attorney for healthcare, which then gives that healthcare power of attorney agent the ability to make that decision in real time, depending on what the circumstances are, and not necessarily depending on what your absolute position is. It's not a doctrine. It's not something that the issue of life support should not be something that you decide yes or no in a vacuum, in a conference room. Instead, it should be something that your agent is given the authority to decide within the context of those circumstances. So clearly, when you have something that could go either way, it is not appropriate for it to be included in the will. So
also, what's kind of interesting too is that if you think about it, the will only comes into effect after you pass away. So it's kind of too late if you put anything about life support in there because you've already died. So that train has already passed.
It is definitely a very good point. Legally, the question is whether there would even be the authority of the personal representative to be able to do that. And so it's just inaccurate and it's wrong and it shouldn't be done. So we are definitely a thumbs down on having anything relative to life support or DNR. We can, definitely throw do not resuscitate in there as well. Those things belong in the power of attorney for healthcare. All right. So what else do you think we should not have in the will?
So a question that I get asked very often is, I have a small business. I have an LLC. I have an S corp. I have things within my under the small business name. I have bank accounts. I maybe have a property. I have these things titled in the name of my small business. Do I need to mention those items in my will? My answer is no. Don't mention those items in your will. Reason being, they're already in your LLC. Think of it like this. The stuff that's within your LLC is your food. Your LLC is your refrigerator. Yourself is the house. I don't want to take the stuff out of the refrigerator and put it on the counter. What's going to happen? It's going to spoil. And then you're going to screw everything up. Leave the stuff in the refrigerator. We'll put the refrigerator in the house. You can talk about what you want your LLC to do. You can say, upon my passing, I want to leave my LLC to my child, or my shares or my ownership stake in anything to my spouse. But no, I would not talk about the assets within the LLC because they're already taken care of.
That really brings up a very good point, and that is just the general concept of leaving specific assets inside of a will. So you can sometimes I have seen, I want this bank account to go to this individual. I want this different bank account or money market account or something like that to go to this individual. I want this property to go to this individual. This is something that I think is very questionable, because what happens if somebody reads that and thinks, okay, let's say Tom, Dick, and Harry are brothers, and Tom and Dick are not excited about the fact that Harry is getting this bank account. So when one of them becomes power of attorney for finances, they take all of the last expenses out of that bank account that goes to Harry. Now, Harry inherits that bank account, but he's getting nothing. So, an enterprising person can really unwind the intentions of the person if the will is stacked with specific bank accounts. Also, have banks been known to go out of business? Have banks been known to be bought out? Have banks been known to tell you, guess what, your account number is completely different? Now here's your new bank account number. All of those things can happen. And now you're looking at a chain of title problem. How do you actually tell what bank account is linked to that particular number? The same thing happens with property. People will say, I want my house to go to this individual. What if the property is sold?
Right.
What if the property gets a massive lien on it? And now what looked like an equal beneficiary arrangement, I say $300,000 is in this bank account. This bank account goes to my son. The house is worth about $300,000. This house goes to my daughter. Now, we have done that under certain circumstances, but it is way smarter to do this type of advanced planning in a trust environment. So there's certainly ways of doing this, but in terms of having those inside of a will, it's too simplistic. And if you decide that you're going to all of a sudden need to take out a line of credit on the house, or the house accrues massive real estate tax debt, there's just all kinds of variations of this where the original intention for there to be an equal split of the assets doesn't actually happen. So that's why we much prefer to say percentages. This percentage goes to this beneficiary, this percentage goes to this beneficiary, and let the assets basically be inventoried and then divided according to what the percentages are. So that's why I would definitely give it a thumbs down to list specific assets to specific individuals within a will. Again, there are ways to prevent and protect an individual's intent, because sometimes it is the intent of an individual to make sure that the cabin up north goes to my grandson. That can be done, absolutely, but it's just way safer if it's done inside of a trust.
Absolutely. And then lastly, kind of in teaching with your IRA designations or any other retirement accounts, people ask us, should I put my life insurance designation within my will that says all the proceeds from my life insurance policy go to this person? Again, unnecessary, redundant, and will only cause issues. Reason being is because the life insurance company ask for a beneficiary whenever they set up the plan. If there's no beneficiary, then there's no point of life insurance, because the point of life insurance is to pay out someone money because you passed away. And so they always ask for a beneficiary. And so there's really no reason to put a beneficiary on the policy at the company level, but then also say in your will that I want the life insurance money to go to this person. It's just not necessary. It's redundant. So do not do that, in my opinion.
I agree. Okay, well, there's some reasons to not put certain things in your will, and this has been fun. So we are glad that you have joined us, and we are here for your today and your tomorrow, and we will look forward to seeing you next time. Take care.